Hello everyone, welcome back. In this video, I'm going to talk to you about the purported mandatory 72-hour hold if you are the subject of an involuntary Baker Act. Now remember, here in Florida, there's two types of Baker Act. Involuntary, which is the one you associate with the 72-hour detention, and voluntary, which is the one you would associate with an indefinite detention. So we've had a number of cases that came in recently where potential clients and even clients said to us, the facility has told us that our loved one must be held for 72 hours. So I went back to the statute just to make sure I wasn't missing anything. It turns out I'm not missing anything, but I'm going to read you the specific section of the statute so that you can see where this is coming from. And I'm referring to 394.463 of the Florida statutes, and I'm in subsection G. So let me read this to you. It says here, the examination period must be for up to 72 hours and begins when a patient arrives at the receiving facility. So one of the big changes for the 24 Baker Act was really defining when the 72 hours starts, because if you've been in a hospital pending medical clearance, it doesn't start until you reach the behavioral health unit or the behavioral health facility. But the language does say the examination period must be for up to 72 hours. So the facilities are saying, well, we must hold you for 72 hours. And I respectfully disagree with that analysis for two reasons. Number one, they can't just hold you because they feel like it. You have to meet criteria. If you don't meet criteria, they got to let you go. So that means if you're there for an hour and you don't meet criteria because they assess you, you get to go. It also says here, the examination period must be for up to 72 hours. Not for 72 hours, but up to 72 hours, which means that the 72 hours is a ceiling, meaning that's the maximum, at least until if they decide to either file to keep you or they try to get you on a voluntary admission basis. So it's not like, well, we get to keep you because the statute says we must keep you. It does not say that. It does not say that. First of all, you have to meet criteria. And two, if at any time during the 0 to 72 hours you do not meet criteria, they got to let you go. That's the way it works. It's not a windfall. So I really wanted to clear that up for you. And I even took a look at the 23 statute to see if they changed the language. They haven't. It's always read that way. I've always interpreted it that way. And I think this section of the Baker Act statute confirms that. So if a facility tells you that your loved one must be held for 72 hours and there's no ifs, ands, or buts about it, either they're just flat out lying to you or they don't know the law. And I'm willing to bet it's probably both of them. They don't know the law, and even if they did, they're lying to you anyway, especially if you've got health insurance and they think they can build a case to keep you, and it's an unscrupulous facility, which is who we typically litigate against. So anyway, I want to share that with you. Just another small, quirk in how the Baker Act is used and interpreted. So with that said, thank you for tuning in.